Okay, good afternoon, everyone. My name is John Bovard, and I'm the owner of Incline Wealth Advisors. And I appreciate everyone joining us on the webinar today. And I'm very excited for our presentation. So one of the roles that I have as a financial planner is to make sure that my clients are set up with the proper estate planning, proper beneficiaries, trust forms, so that their wishes can truly be passed on, and that their money is passed on the best way that they see fit. So no better person today than to lead us through the discussion around estate planning and asset protection strategies than Alethea Teh Busken. So Alethea is an attorney at Kohnen and Patton, and she specializes in estate planning, and I've seen Alethea's work firsthand. She does a great job. So very excited to hand things over to Alethea today to have her walk us through her presentation.
Thanks, John. It's always a pleasure working with you. Hi, everyone. I hope you can see the screen. My name, as John said, is Alethea Busken. I am a Cincinnati attorney practicing exclusively in estate planning and probate, which I love to do. And I may find it very distracting to see myself on the screen. So I'm going to try to maybe not too much at it. But I can discuss estate planning all day long. And I know it can be confusing. So we're going to start about the basics of estate planning, talk about some asset protection. You may hear people talk about getting their wills done, which is sort of what I hear my neighbors talk about. It's another way to say estate planning. Somebody's doing estate planning. And a will is typically what people think of. So we're going to talk about wills, we're going to talk about trusts, financial and healthcare powers of attorney, how to use beneficiary designations, and an overview. Let's see. There we go. And an overview of asset protection strategies. Since I'm a lawyer, it's almost mandatory that I start with the disclaimer. Because I'm speaking very generally about estate planning, this presentation presumes advice for a person who is married. Oh, I'm supposed to move this away. Okay. For a person who's married, leaves all their property to their spouse, and then to the children of the marriage equally. Obviously, families come in many shapes and sizes, and although the function of the estate planning documents that we're going to talk about are similar for people in other situations, I will be gearing my remarks more toward kind of the traditional family. This is telling me to move something away. Okay, so estate planning is the legal process by which you plan now for the handling of your affairs one day in the future when you can't take care of them for yourself because you've either passed away or you're incapacitated somehow. We think we own the property that we own in different ways, and so there's a legal way to pass on that property when we die. I think of property in three different categories. The things I own because I possess them, because I bought them and they're in my possession, my stuff, like household furnishings, electronics, artwork, jewelry, clothes, things like that. Then there's property that you own by title because you own your house by a deed publicly recorded at the county recorder's office, a car or boat by title recorded at the DMV. And then there's property owned by contract or agreement, things like bank accounts, retirement, life insurance. You make a contract with the life insurance company to pay a certain amount every month. And then they will hold up their end of the bargain, their contract, by when you pass away, paying the money to your beneficiaries. And as long as you have beneficiary designations, that kind of property owned by contract will pass outside of your will according to the contract. So a typical estate plan will have these documents. So when I'm talking about estate planning, these are the documents I'm going to be referring to. For The two above the line, you'll see there's a line there. Two above the line take care of things when you're deceased. And the ones below the line are for when you're living but can't take care of your affairs for any reason. A critical part of these documents is the selection of the person you name to carry out your wishes. So as we go along, the positions of trust appear in blue, kind of a bluer font, and should remind you to think about people you trust who can fit these roles. You may hear that celebrities die. Every once in a while it makes the news, such and such celebrity died, but what really makes the news is that they died without a will. They died without estate planning, and you think they have all this money, they have a lot of lawyers. For whatever reason, they didn't place importance on drawing up an estate plan. More than 60% of adults in the US don't have a will, which doesn't have to be a bad thing, because there are like default laws in every state which say what happens if we die without a will, where our property goes. And if those laws happen to line up with what you want, then you might be okay. But if you don't want that, to leave that to chance, you need a will. A will, a last will and testament, does many things. It's the legal document where you state your wishes regarding the distribution of your property and appoint a guardian for your minor children. Some people say, oh, I don't have that much stuff, why do I need a will? But if you have minor children and both you and your spouse pass away, then the court decides. It's left to the court to decide who will raise your children. And most people don't want that to happen. So the will is the place to name a guardian for your minor children. You also gift your property to beneficiaries. Again, this is property that is part of your probate estate, not things that pass outside of probate by beneficiary designation. But in the will, you leave your stuff, that tangible personal property, to whomever you wish. This is what my wills typically look like when I set them up, a tangible personal property section. And you name an executor to carry out your wishes. If you die without a will, you are said to die intestate. And in Ohio, if you die without a will, your probate property will generally go first to your spouse if you're married, then to your children if you're not married but have children. If your spouse is not the parent of all of your children, then there's a division there. And if you don't have those people, then it goes to your parents. If you don't have them, then siblings, then grandparents, aunts, uncles, cousins, next of kin. And if you don't, including step family, and if you don't have any family at all, then all of your probate property will go to the state of Ohio. People usually don't want that. Having a will then ensures that when you die, your property goes to the people you want it to go to. So that's the basics of a will.
Yeah, so Alethea, I got a quick question on that, because it comes up pretty frequently for me, and that's around property that you're passing on. So if someone has maybe a family heirloom or expensive artwork or jewelry, anything like that, do they need to specifically list out those items? Like, do they need to list out a certain painting, or is there kind of a blanket, one size fits all that'll take care of those possessions?
That's a really good question, and something that people ask a lot. For something that you really, really, really want to make sure goes to a specific person, you can list it in your will. There's reasons not to do this, because a will is public and it is public information in Hamilton County. It is made available on the Hamilton County Probate Court's website, and people look through there and see who inherited, the diamonds and that kind of thing. But if you really, really have, a Picasso, some valuable jewelry, you can list it in your will, and then the executor must make sure, and the court will oversee that distribution. However, there's another way to pass that property along, and it's kind of what we recommend instead of a will, and that is to put your valuable property into your trust. You can execute kind of a simple bill of sale from yourself to yourself as trustee of your trust, and then have a provision in your revocable trust to deal with the valuable property that you have. So you can say, the Picasso goes to Cincinnati Art Museum, or to your eldest child or whatever. Or you can say, the diamond jewelry gets divided in this way. So you can get very specific without it being public. The other thing we do is that because property, maybe we'll give it away during our lives, maybe we'll get something else. Instead of changing your documents all the time, sometimes in our trust documents, we'll say, that the trustee should distribute this list of property that I have written down. I've signed it, I dated it. This stuff goes to this person, or, sometimes people have valuable property like that listed on a rider, an insurance rider, and they'll say, everything on the rider goes to this person. And you keep that with the trust. You don't have to keep changing the trust document, but you can change that document, and the trustee honors that. So that's sort of what we recommend for those kinds of items. Also, a really good way to do that is to give it away while you're living. And that's, you may not want to do that, but a lot of people do that too.
Right.
Does that help?
Yeah, that's great.
Okay. Okay, I was talking about trusts, why we have a trust. They can be confusing for people. I totally get that. Wills and trusts definitely work hand in hand. It's a myth that trusts are only for very wealthy people, although of course very wealthy people are very used to trusts, because they're really familiar with the legal mechanisms by which they pass, their wealth onto future generations. But it's not just for people with lots of money. My parents have a trust and they don't have a lot of money. So it's, as stated here in this slide, a revocable trust is designed to hold assets and direct distribution of assets upon the death of the settlor. And the person who sets up the trust is the settlor. So my parents are the settlers of their trust. And a trust requires a trustee, somebody who carries out the terms of the trust. So right now, while they're living, my parents are trustees of their trust. When they pass away, they have designated successor trustees. After they're gone, I'm their successor trustee. I have 3 siblings. So I'm the one who is going to then take the trust document and follow the wishes of their trust. So I'm going to discuss 5 reasons why a trust is good, why I would recommend a trust, and why people have trusts. Probably the biggest reason we see is to avoid probate. And because I just talked about John's very well-timed question of specific assets that are valuable, specific property, tangible personal property that's valuable. A trust can act as a will substitute. So a trust does not go through probate. It doesn't have the oversight of the court. It is kept private. So we'll talk about that a little bit further. Another reason is to control the way you leave money to minor children. Third, and that's a very common a reason why people have trusts too. To keep family money in the family and to protect assets, and we'll talk about that a little bit more, and for tax planning and other reasons, especially for estate tax planning reasons. And estate taxes don't affect the majority of us, but if you start to be worth multiple millions of dollars, you are going to start thinking about that and being aware of that.
Yeah.
Okay.
Yeah, a great point. And Alethea, one thing that I would ask is, so it sounds like you're the trustee in your parents' trust, and obviously you're very qualified to handle those duties. But if someone's looking for a trustee for their trust, who do you typically suggest? I know there's several different options between, you can name a corporate trustee, or it's an advisor or a family member. Who do you typically advise that serves as a good trustee?
That is a very good question, a common question. If we're talking about, I would say most of our clients name a trusted family member. Often it's children who are just pretty good with administrative stuff. They have a decent head on their shoulders. These are family situations where there's not going to be a lot of disharmony. If I'm in charge of getting these assets to my siblings, they're not going to be mad at me if I take a little extra time, or if they think I'm being unfair. It's not going to ruin our relationship, that kind of thing. And so it's okay to name a child as a trustee, or multiple children as co-trustees. If you were talking about asset protection and you're concerned about protecting assets from potential child's creditor, bankruptcy, a divorcing, if your kid's in a rocky marriage, they might get divorced. If you want to add some protections around that, a corporate trustee is a really good way to go.
Okay.
All the local banks have a trust company. Incline, I'm guessing, is partner has a trust company that you recommend.
Yes, right.
Um, um, a trust company also, so PNC Bank, US Bank, Fifth Third Bank, those are the big banks in town. They
Right.
all have trust departments. They're great. They do a great job. They add a level of objectivity that you might like as the person who sets up your trust. Their relationship isn't going to be ruined with if it's your sister who's the trustee for your children, so it's Aunt Linda who is this trustee overseeing assets going to your children. If you're worried about Aunt Linda and your kids having a bad relationship, you might want a corporate trustee
Right.
who are, do a great job and aren't going to charge their fees. They will have fees. They're not necessarily a lot more than what Aunt Linda would spend hiring somebody like John to invest the trust assets, hiring CPAs to do the trust tax returns and things like that.
Okay, great.
Hopefully that helps. Sounds kind of a long answer. Okay, why do we want to avoid probate? And again, this is kind of the biggest reason that in Ohio, at least, we recommend having a revocable trust in addition to a will. Probate property is anything that passes without a beneficiary designation. Of course, we've discussed that. And because it's through a court, it's public record. You can go to and I used this example before because Prince, the recording artist Prince had just died. You can go to the county where he died and look up his probate estate. And there are literally thousands of documents about, and there's a lot of them are acrimonious, people claiming to be his children, lists and lists of the property he had, all of it's public. Closer to home, if you can go to the Hamilton County probate site, people look through there. I get calls all the time. Executors get calls all the time when they see that there is real estate in, one house is in the probate estate. You get calls, people just know. So people like to avoid the public nature of probate. Probate can also be costly. You frequently need an attorney, like me, to make sure all the transfers happen correctly and to administer the probate. It can cost thousands and thousands and thousands of dollars, maybe. Whereas setting up a trust, maybe a couple thousand in the beginning, that kind of thing. But on the end of it, it can be a lot of money. And it's usually very time consuming. I rarely see a probate last less than a year, maybe 2. And at a time when people are grieving your death, kind of the last thing they want to do is deal with probate. And then every once in a while, a couple dies in a common accident, and their family has to do a double probate. So on the other hand, if property passes through a trust to beneficiaries, it avoids that whole process. Number 2, the reason people have a trust is if you leave your property to children or grandchildren, and any of them are minors, the court will often have to appoint a guardian of the child's estate to hold the property until the child is 18. This is a court-appointed position, which means it has court oversight, so there's a cost to the reporting, and most children upon turning 18 are not ready to receive thousands or hundreds of thousands of dollars. If you think about your children, think about yourself at age 18. By using a trust, you can control the money left to children. And I'm not talking about, little children, I'm talking children of any age, adult children as well. You can choose a distribution standard for the trust income. So the money that's invested that kicks off income, dividends. You can, say how you want the income used. And then you can also choose a distribution standard for the trust principal, that corpus that gets invested. You can limit distributions for child support, which is, for healthcare, education costs, basic maintenance and upkeep. Or you can permit like really liberal distributions for their best interests, and which is whatever they can convince the trustee is in their best interests. So whereas, I always give this example, whereas support might include replacing their, Toyota Corolla or Honda Civic or something, a best interests standard could mean a Corvette or Range Rover or something. By using a trust, you can spread out the withdrawal of money also over time. You can say that a child can have full access, withdraw their trust funds, their trust money, like a third at age 25, a third at 30, and a third at 35. And that's very common. We see a lot of people doing that, so that they get it staggered, and they can hopefully be learning to use the money, take care of it wisely. I've even seen people keep money in trust for their children until they're 60, and then it becomes more of a retirement fallback. And these are people who really want their kids never to rely on trust money and things like that. You can leave money to grandchildren in this way, and you can use it to create a legacy. I have a client who left 100 shares of P&G to each of her nieces and nephews, and there were a lot of nieces and nephews, but the trustee was given the mandate to impress upon them that this was part of their legacy because their great grandfather helped build P&G into what it is now. And so that kind of thing. You have this freedom and this flexibility in a trust. Another reason to have a trust is to avoid the diversion of family money away from the family. And this is, I see this a lot. I'm going to move some things around here so that I can read my slide. For married children who do not have children, when a child dies, the child's spouse typically receives the funds. So giving funds to children in trust can avoid diversion to people who are not descendants. And by this, I mean that, let's say my parents leave me $500,000 when they die. I'm married, but I don't have children. So, so that as I die suddenly, we're going to say. And so my husband inherits my property, including that $500,000 of my parents' money, which is now diverted away from my family. So if my spouse remarries, the money can completely leave the family. He may, if he remarries and they have children, that $500,000 that was my parents is now, this other family's money. So that's, my parents may be fine with that, but they may not have liked that. But if my parents used a trust, which they have done, and leave me that same $500,000, they could do it in a way so that I can access what I need. But when I die, any money that's left goes to my brother or his children or things like that. And that way much family money stays in the family. That's another reason people use a trust. A trend that we're seeing more and more of, and it may be why you are here because you're interested in asset protection. We're seeing this. It is a huge area right now and a huge reason why people seem to be have interest in setting up trusts right now, even when they don't have that much money. It's the desire of parents to tie up money in trust to protect their child's inheritance from creditors, including a divorcing spouse. And you don't usually think of a divorcing spouse as a creditor, but with the number of divorces happening right now in this country, it is definitely something to be thinking of. You can imagine that if your sweet daughter is married to an irresponsible, philandering husband, and they divorce, he may try to claim half of that $500,000 you left her. But if you leave that $100,000 to her in a way, in a trust with distribution standards and no right of withdrawal, it can be available to her, but out of her control enough that a creditor or a divorcing spouse is prevented from reaching it. And so this is also where having an independent corporate trustee adds a layer of additional protection. And so we may discuss that a little bit further. We'll see.
Yeah. I got just to a couple of questions. Obviously, you covered a lot on trust with those past couple of slides. So some of the scenarios that come to mind that I think of is, if someone were to get remarried and, your new spouse, you want to ensure that your money gets passed on to your own kids and maybe not your new spouse's kids. Is there a way to set that up or
Definitely.
set that in place?
Definitely. Great question. My next slide. At the bottom of my next slide, there are like loads of reasons why people leave money in trust. At the very bottom of the slide, it says second marriages or more complex family situations. We recommend two separate trusts when, in kind of let's just say the Brady Bunch family, right? Mike and Carol, I think that's their names. They had 3 children of their own. I would recommend that they each have their own trust. so that assets in each person's trust are separate. When Mike dies, because the husband usually does die first, Mike dies, the assets in his trust can be available to Carol for her needs while she's living. But then when Carol dies, those assets go to his children, not her children, unless he changes it, unless, they've come together so much, and he considers, those children his, or what, and he can do whatever. But yes, that is a really good way to keep family money in the family, and certainly not to have it diverted away to other, to the children of another marriage.
Yeah, great. And another question that comes up pretty frequently as well is, do you advise your clients to put their home into a trust, whether that be a Q-tip trust, or how do you normally handle that conversation?
Yeah, we typically do recommend that, unless they think that they're going to they're going to move in the next few years. Often people do that as a way so that you can put your house in trust right away. You can, buy it and title it to yourself as, John Bovard, trustee of the John Bovard and, family trust or whatever. Or you can, in Ohio, we're lucky that we have a transfer on death designation. Basically, it's a beneficiary designation that you could put on your house. Okay. It gets recorded with the recorder's office. And we have a lot of people do this, where the house is titled into John and his wife's name jointly with rights of survivorship. If they both pass away, and they have a transfer on death designation recorded, the transfer on this affidavit is going to say, if both John and his wife pass away, their house goes into their trust. And so it gets transferred into their trust at that point, and it becomes trust property. It passes outside of probate, which is wonderful. And then it's held there, and the trustee takes care of it according to the terms of the trust. So okay. There are both, those are both reasons to do it. Sometimes people don't want to title their house into the name of their trust right away, because you have to find out if your homeowner's insurance is going to be good with that, your mortgage people are going to be good with that. Titling it a little differently, there may be issues. Mm-hmm. So good questions. Yeah. So we're not going to talk about some of these more complex things and reasons people use trust. This is sort of a basic, but people do use trust to plan for taxes, especially estate taxes. The estate tax exemption right now is $11.5 million. Most of us aren't going to have $11.5 million. Some of us will, and so you want to consider more advanced tax planning, which we do here, and it's a lot of fun to get really complicated. Okay. So those are the documents we've just talked about that you need to take care of your affairs at death. There are affairs documents to take care of your affairs during our lives. So I want to talk about those really briefly, because there may be times when you can't handle your affairs and need someone to do that for you. Perhaps if you're in a car accident, you end up being in the hospital for a while, you have a terminal condition, early onset Alzheimer's, have a stroke. There's all kinds of reasons. You're out of the country unexpectedly, and COVID doesn't let you come back to your country or whatever. You might need somebody to write a check, take care of things. Having a power of attorney is incredibly helpful, a financial power of attorney. So you name somebody who you trust. And then there's healthcare powers of attorney, living will declarations, and these documents are no longer valid at death. So when you die, the validity of these documents goes away. For your durable power of attorney for finances, you name somebody trusted to handle your financial affairs. You can limit the powers you give this person, or you can give them really broad powers. Again, it depends on what you need to have happen and how much control you want to permit your agent to have. You can make this document go into effect immediately upon signing, or you can have it be springing. It can go into effect only upon the declaration of your incompetence. And there are issues that people have with powers of attorney. We have found that locally banks are kind of balking at honoring powers of attorney that are older than 5 years old. simply because it's hard to prove that these documents haven't been revoked somehow, or, you know, and there's liability, they fear liability for them. So for example, or they may have their own form that they want you to fill out. I know like Chase Bank had me fill out, they didn't really want my parents' power of attorney form. They wanted me and my parents to go in together and fill out their power of attorney form. Everybody's a little different. So if the document's stale, you know, older, then that's a reason to have a fresh power of attorney drawn up. I have a friend right now who I'm trying to help out, whose husband is 42 and had a stroke out of the blue 8 months ago. They have 5 kids. They're trying to sell their house this summer. They own it jointly, but he can't sign the deed, and he didn't have a power of attorney. So we're trying to sort that out. It might lead to a court-appointed guardianship, which is, you know, months and money. Anyway, power of attorney, highly recommend. Healthcare powers of attorney, something we recommend to everyone age 18 and over. It's effective only when you can't speak for yourself. So just because you give somebody the ability to make, you know, you name somebody your agent under healthcare power of attorney, they can't just make healthcare decisions for you. You name an agent and alternates. And because after you're 18, your medical records are protected, you can authorize your agent to access them in this document. You can authorize your agent to make end-of-life decisions for you, or not. You can say that they're not allowed to. And you should always give copies of these documents to your primary care doctors and hospitals. They'll ask you if you have these documents. Finally, there is a living will declaration, and this only comes into play if you're in a terminal condition and have no ability to make decisions for yourself, or you're in a coma. This is a declaration directly from you while you're well and whole to your doctor, saying that you want the dying process to occur naturally and don't want extreme measures taken. It's not a DNR, but it does authorize the doctor to sign a DNR. And this is, in this document, you say that you want to die naturally, to be given comfort care, and then you choose the people that your doctor should notify. And so that's, some people have really strong feelings about that. And so you may or you may not really want a living will. A key part of estate planning, and I can't emphasize this enough, and I know, I'm sure John looks at this a lot, is the use of beneficiary designations for life insurance, IRAs, 401ks, other retirement assets. That money will go to whoever you designate on your beneficiary form. And you should look at this regularly, especially if you have children, adopt children, marry, divorce, that kind of thing. If you don't designate anyone, your money will pass to your estate. It'll go via the probate process, so that, you know, under your will, or if you don't have a will, under the probate process. You can also put a beneficiary designation on a bank account, just your regular checking and savings account. These are called payable on death designations. You can ask for that. Put one on your investment account. It's called a transfer on death designation, TOD. You can even put a TOD on your cars, at the BMV. We don't always recommend this because a lot of us go through cars fairly quickly. So it may be worth it, may not be worth it. And then there's that TOD affidavit for real estate. So you can even put a beneficiary on your house. Okay. We briefly talked about asset protection when we were talking about trusts. This has become, I don't know if people are just getting sued more or just more conscious of these kinds of things, but people are really interested in this. So several strategies ranging in complexity to consider. If you're concerned about liability, concerned about being sued, if you're concerned, you're in a high-risk profession, if you're a neurosurgeon, if you have creditor issues, if you're concerned about people taking advantage of your children. So a basic level of asset protection, kind of the most basic level strategies, would include having sufficient insurance. When was the last time you sat down and looked at your deductible and your personal liability? Would an umbrella policy be enough? Is the umbrella policy you have enough? If you own rental property or family-owned property or real estate, do you have the proper coverage? Do you have the right kind of property insurance if you're renting, and then do you also require your renters to have rental insurance? So those are some things to consider. Have you considered changing your IRA to a Roth IRA? I'm not going to be able to advise you a lot on that. That's something to talk about your financial advisor, your CPA with, but I know that that's a strategy that has some protection. And then we call it the poor man's asset protection, just changing titles to your assets. Rental properties go into an LLC, or the riskier spouse, the neurosurgeon spouse can put all their property into the elementary school teacher's name, or even better, a trust in her name, and that can often give a level of protection. Looking at kind of a mid-level of protection, something that we do a lot of, it's that, like I talked about, that revocable trust with protective provisions, a wholly discretionary trust, that the trustee is the one to make all the decisions about when to make distributions to the child, with a child having no right to demand, there's no age at which they have a right to withdraw, and having an independent corporate trustee. All those things add layers of protection for the assets left in trust for a child. Irrevocable trusts, life insurance trusts, are a good way to protect assets so that there's always kind of enough there if something else happens. And then there are LLC strategies, so that you put property in an LLC, and then the LLC is owned by different entities that you set up. Maybe one of the LLC members is a trust, is an irrevocable trust, all these kinds of things. Those are ways that you can build layers of protection. And then kind of the most advanced levels of asset protection are actually domestic asset protection trusts. There's foreign asset protection trusts. I'm not going to be able to advise you on any of that. Domestic asset protection trusts, though, we do a lot of. These are for our higher net worth clients, typically, who have money to put away that they'll never need. They want it protected for descendants. The Ohio's Legacy Trust is a newer form of trust that Ohio recently accepted in the last 5 years, I want to say. We do a lot of these. One of the partners here was part of the legislation of having that passed. And that means that, people who typically go to Delaware or a state that has asset protection trust laws. So now Ohio is becoming, kind of more looked at as offering those protections. They're much more complicated, but absolutely something to consider if that's a concern for you. Spousal lifetime access trusts, SLATs, if you're concerned about asset protection, that's a good way to do it. Qualified personal residence trusts, that's something that you can look at. Things that we do that I'm not really going to cover here. But all of these documents and strategies definitely work together to effectively pass kind of your hard-earned wealth, your money, everything that you worked hard to acquire to your loved ones when you die, to take care of them. Just like planning a vacation, sometimes people put a lot of time into planning each step of vacation, plan A, plan B, planning a wedding, even though in the time of COVID that's become a little different. Planning a wedding, typically years can go into that, or not. Estate planning can be that simple, or it can be complex depending on your situation and what you want to achieve. So this has been kind of a very simple look at estate planning. I'm happy to take questions. If they are very specific, I may have you email me directly. If I don't know the answer, you can email me, or I can email you. But I do think that, I guess the last thing I'll say, that I always say, is that a good estate plan is the last loving gift that you can leave your family and friends and the people you care about. And I found that to be true. I do probate as well, and so I hold a lot of hands when loved ones die, and a good estate plan simplifies so many things. So I've seen that firsthand. Any questions, John?
Yeah, thanks a lot. I mean, that was a lot of great information. Definitely a lot to think about. And yeah, I do have a couple of questions, that came up just as you were talking. So one of the questions, and it's more, I'd say more of a kind of specific situational question, but say either someone that's older that might be single, or maybe they're even a married couple, and they need to go into a nursing home. Um, I guess a couple of questions I would have, but maybe they didn't want to sell their house, maybe they wanted to pass on their house to beneficiaries. Would it make sense to put the house into a trust in that standpoint, or with the nursing home, if they say for whatever reason maybe they ran out of money, could they go after their assets, go after their home? What have you seen there?
That's a good question. A lot of people have that question. That's sort of where you get into some elder law and even Medicaid planning. There is planning that you can do when you anticipate going into a nursing home. There are certain things that, yeah, you can leave your residence, for example, in trust or put it into the name of the spouse that's probably not going to need it. Um, for certain situations, if you do it within well in advance, so 5 years in advance of needing, say, Medicaid, then you've done it in enough time that Medicaid can't claw it back. For folks who are self-pay in a facility, an assisted care facility or whatever, there are different ways to do that. I'm not an expert in that area. Chad Levin in our practice does a lot more planning for those kinds of reasons. But I knew that putting a home in a trust often provides that kind of protection. But there's just all these details around it, the timing of it, the way you do it, that play into that. So
Yeah.
it's not the greatest, most straightforward answer, but
No, everyone's situation is different.
yeah.
Yeah, I know that there can be many different levels to this. And yeah, I guess another question that I have as well is, so with the tax cuts that happened back in 2017, those raised that estate tax exemption level to number of assets. So obviously, anytime there's a change of office, that can lead to new tax policies, new estate planning policies. Do you see anything proposed that would change, if there was a change in the White House, and if Joe Biden were to win?
Sure. We're at present attending seminars on this very question, right?
Yeah.
Every time that there's a new Congress, there is a possibility that the estate tax exemption level will change. Previous to the Secure Act being passed at the end of 2019, the estate tax exemption level was $5.5 million indexed for inflation. And so that means you can give away during your life and at death up to $5.5 million or whatever without incurring any estate taxes. But if you are over that amount, anything over that amount incurs a 40% estate tax payable to the IRS. And so people don't obviously want to do that. And so there's all this planning that you can do to avoid that, to separate assets, to have credit shelter trusts and things like that. With the new so number one, with the Secure Act, the current administration raised the estate tax exemption level they doubled it. So it's now 11.5 million indexed for inflation. And so we can each pass away. A married couple can pass on, what is that, $22, $23 million without worrying about estate taxes. So good for them. We will, but that is set to sunset at the end of 2025. So if you die January 1st, 2026, it's going back. It's set to sunset. It's going back to the 5.5 million. We don't know what a new Congress will do. We can speculate, and there's a lot of speculation, people who speculate professionally. And we do know that the money typically has to be made up somewhere. And so even if, I doubt that the estate tax exemption, personally, I don't think that it'll ever be completely done away with. It may be brought back down to $1 million or $3 million. It may just go back to the 5.5 that it was. There are definitely something to keep an eye on, something to plan around. It's very possible. Also, it is likely that if it stays as high as it is, capital gains taxes will change, and that is another way that people do planning. Right now, when we die, the deceased person's asset get a step up in basis. So if they've been holding on to stock for a long time when it was worth, very little, and during their lifetime it grew, the value has grown, and at their death, the basis gets stepped up. So the person who inherits that stock gets that stock at the value of the date of death. So they get all that awesome growth tax, free. That may change if the estate tax exemption stays high, because the government has to get money from somewhere, and there's a huge debt right now.
Right.
So there's a lot of speculation that will change. One thing that the Secure Act did do, which is important to know, is it changed the way retirement assets can be passed on. Previously, a grandparent could leave their retirement money, an IRA, to a grandchild, and the grandchild then, well, they can still do that, but the grandchild would receive this IRA, this retirement money, and it has to be qualified retirement money, over the stretch out of their own life expectancy. So if a grandchild, is 20 years old, their life expectancy is long, and so they're going to get the benefit of this retirement money that gets stretched out over their lifetime. They get distributions. They pay income tax on that distribution. They're probably at a low income tax level because they're so young. But anyway, it gets the stretched out growth. With the Secure Act, one of the things that it did change was that no longer can we stretch out distributions to grandchildren, say. Distributions to a spouse can be stretched out, or an IRA retirement plan to a spouse can be stretched out for the surviving spouse's lifetime. But distributions to children, retirement assets left to children and other people, have to be distributed over 10 years. So they only get a 10-year stretch now instead of the lifetime stretch.
Yeah.
So that's something that changed, again, because they do have to get money from somewhere. That's something to be aware of if you were planning on your retirement assets. If that's a major part of your estate, and you were planning that you've named your kids or whoever, your grandchildren, as beneficiaries, just to be aware that they no longer get that stretch out.
Mm-hmm.
So we can't predict the future.
Yes.
We can guess at things because of history, but that's something to keep an eye on, that we're totally keeping an eye on.
Right. Okay, perfect. And anyone, any other questions from anyone that has joined the call today?
Is that Lauren from PNC? I see Lauren's name from PNC.
That's right. You may need to unmute to ask a question.
Hey, Alethea, no questions, but great job. Nice to see your face.
Nice to hear you. Yeah, great. If any questions, I don't know, there's some, let's see. Oh, pause my screen share. Oh, sorry that there was a stuff on my slides. I didn't see that.
Yeah, no worries. Lastly, I would just end with, when I tell my clients, and it's good to spend a little bit of time, spend a little bit of money right now on, getting your estate plan set up, making sure, if it's a will, if it's a trust, you'd much rather take care of that now, get everything set up, take the time, spend the money, so that, because if you don't, it can be way more timely for your beneficiaries, and it can be way more cost prohibitive in the future without having any sort of trust or will set up. So highly encourage you to, right now, while you've got your health, while you've got, hopefully a long and prosperous life expectancy, that you get this stuff taken care of. And, you meet with Alethea. They do a great job. Like I said, they, handled my estate plan, got everything set up for myself as well, to make sure that if anything happened to me or my wife, my kids would be taken care of. So highly stress that it's very important to make sure you have something set up.
Great.
All right.
Thank you.
Yeah, we'll wrap up with that. Thanks, everyone.